For those of us who thought since Corey Fleming pleaded guilty to his state charges and we weren't going to get to see a trial with some of our lovable folks down in South Carolina, we had a chance to see a very mini version of a trial for his plea hearing. We'll no doubt see more at the sentence hearing, tentatively set for September 14th. We found Creighton at his best, outlining Corey's actions and preemptively blocking his chance to claim innocence for his part in stealing from his and Alex Murdaugh's clients. He came with exhibits and timelines, much like what we saw in the murder trial. And we got to see my favorite judge in the whole wide world, Judge Newman, ever attentive and interested in his cases. I've seen my share of judges who sit on the bench looking like they'd rather be anywhere else, and you wonder how much attention they're actually paying. But Judge Newman is always paying attention in his courtroom. Earlier this week, I played an excerpt from Attorney Limehouse's interview after Russell Laffitte's federal sentencing, highlighting the difference between Russell and Corey as far as Russell still proclaiming to be innocent and Corey pleading guilty on both federal and state charges. She gave Corey credit for doing so, and I agree. But I also agree with Creighton Waters' take on it. Plead guilty, but don't pretend you were hoodooed by Alex. His righteous indignation was palpable. Corey muddled the entire profession, but most notably, he and Alex together just about destroyed the reputation of that whole area of South Carolina, if not the whole state. It will forever be a part of history and will certainly affect the way people feel about the place and the profession. It's in that tone that Creighton addressed the court, and though I made the statement in the last video that I doubted state sentencing would be more than federal for Corey, I now question that. You want to see the highlights? Let's get started. This is Cassidy O'Connell with Legal Updates with Cassidy. Episode 6, The Dumbest Man Alive. Welcome. I want to cover the highlights from the hearing itself. For anyone wanting to see the entire coverage, you can find it at Fitz News, and I will pin the link in comments. It's definitely worth watching in its entirety, and I'm really grateful it's available since I couldn't find a televised version. Corey Fleming, and especially Russell Laffitte, somehow get to fly under the radar most of the time, so a lot of people are not even aware of just how culpable they are in this whole mess. So Creighton begins the hearing by saying that the state demands resolution.
Today in state court is the first time that we're going to see accountability for abuse of the state court system.
He goes on to say the state's judicial system has to have accountability for someone who has abused that system. Describing Corey, he goes on, for a state lawyer who had a state law license to abuse that state law license, state court actions before state court judges with state court settlements and things that happened within the state of South Carolina, how the system was abused, calls for state accountability. Now, I've heard that there was a little bit of hard feelings between the state and federal cases. I don't know how true that is, and I don't know if that's why he's emphasizing this or not. But you can feel his passion for wanting to clean up his state's judicial system. He then begins summarizing Corey's case. He says it basically began around the time of Alex's so-called roadside shooting. It was at that time that Alex's crimes were being uncovered, and a grand jury started investigating the financial crimes. As a result, Corey's share in the scheme was becoming realized as well, and his initial reaction was, I was hoodooed by Alex. I was led down this path by Alex's deceit. And at that point, all that's been uncovered is the Satterfield case. Which, speaking of the Satterfields, they were not present for this hearing, but they do plan to be there for sentencing, and it's possible that they might give witness impact statements. Mr. Waters goes on to outline how Corey couldn't have just been a pawn that was deceived by Alex, as some of the thefts he stole on his own, independent of Alex. How was this deception by Alex?
And one of the first things that we uncovered was that Mr. Fleming had been stealing money out of the Satterfield account, independent of anything to do with Alec Murdaugh and fake.
Then, as this investigation continued, the Pinckney case comes to light too. A case that happened way back in 2011. How did Corey handle that case?
And that was one of the big cases that Alec had. It was a huge recovery, but he had to bring Corey in to represent Pamela Pinckney because she had been a driver in that particular incident. And one of the things we saw, and I'll go through this in greater detail in a moment, was Corey Fleming authorizing money going from the trust account that should have gone to Pamela Pinckney and instead sending that to PMPED, which Alec Murdaugh then promptly converted. And as we look further at that, we started looking at the expenditures. And one of the things that we saw over and over again as we look at this case, as we look at how the system is abused, is that when settlements were received, these attorneys would often retain in trust an amount sufficient to cover any medical liens that were on the case. And what they're supposed to do, as Your Honor is well aware, what they're supposed to do, and what they often do, is then negotiate with those medical providers for a lesser amount. So if it's $200,000, hey, we'll pay you $125,000. And then if the medical provider agrees, what they're supposed to do as a service to their client is then return that delta, return that difference, that $75,000 to their client. But instead, for Mr. Fleming, that was an opportunity to steal.
Next, he gives a quick tally of the stolen funds.
This is a list of the loss amounts, which also was kind of an overview of the charges that we will go through here as part of the factual basis here today, Your Honor. And if we look at this particular chart, you can see at the top you have the 3 Satterfield forged checks. You have 3 checks of expenses that Mr. Fleming stole independently from the Satterfield account. You have 2 amounts that Mr. Fleming stole from the Pinckney Trust settlements. You have the nearly $89,000 that instead of delivering to his client, Pamela Pinckney, he instead sent to Alec, as well as another check of fake expenses that he delivered to Alec. And the state's total amount calculated of loss attributable to the actions of Corey Fleming and his law license and his abuse of that is $3,725,203.85.
He points out that in the beginning, the case was operating normally and that Corey established a relationship with Miss Pinckney, which is kind of more disgusting to me, because how do you spend time with and get to know someone in her situation and then steal from them? For those of you who might be new here or haven't heard about Hakeem, here's a clip from a previous video of mine.
Hakeem Pinckney.
Again, I don't know that I talked to Hakeem, but I certainly allowed.
On August 22, 2009, Hakeem Pinckney was critically injured in a car accident along with his mother Pamela, sister Shaquara, and cousin Natasha Thomas, when very similar to the Plyler family, a tire tread separated on their vehicle as they traveled also on I-95 like the Plyler family. Hakeem, who was thrown from the car, was the most seriously injured. His mother was also seriously injured, and according to her lawyer, has had more than 15 surgeries since the accident. Hakeem has a triumphant personal story of a boy who, although deaf from a young age, managed to make a success of himself. He attended the South Carolina School for the Blind and Deaf, had perfect attendance, was Student of the Year, and even played on a football team before tragedy struck him a second time, rendering him quadriplegic. Hakeem was in a care facility, unable to move, when his life support is mysteriously unplugged for 30 minutes. He suffers a stroke and, though rushed to the hospital, succumbs to the damage of being without oxygen for so long. His mom, Pamela, had been waiting for a settlement to get him out of his care facility and into a better one that she couldn't afford until the settlement was awarded. His mysterious unplugging happened 2 days after the case was settled in court and before the money could be distributed. This is wildly suspicious, and I don't understand why it was never investigated. After surviving this crash, seeing her daughter, son, and niece injured, then her sweet son dying, she's also left with severe injuries of her own. And this woman, this tragic woman, is the woman Corey and Alex see fit to steal from.
And one thing about that is Mr. Fleming did what a lawyer is supposed to do and communicated with Ms. Pinckney, developed a relationship with Ms. Pinckney. And you can see right there, that's a normal payment. It's from the Moss, Coon, and Fleming trust account, and it's made out to Ms. Pinckney, as it should be. And I point out the normal one because we'll see how things change down the line.
And what did he steal her money for?
And as we were looking at that delta, that difference between what Mr. Fleming had retained in his trust account of Pamela Pinckney's money and what he had actually settled the lien for, we said, we got to look at those expenses. That's where something's fishy. And one of the things we saw in there was a reference for a medical expense to Crosswind. A medical expense to Crosswind. Well, something didn't seem right about that, and state grand jury staff and SLED started looking around, and instead of finding any medical entity called Crosswind, what we found, Your Honor, you can see the invoice right here, was a Crosswind Aviation, which provides private plane services. And so SLED goes and interviews the pilot, and he's like, yeah, I took Alec and Corey out to the College World Series. They wanted a private plane to go out there and party, have a good time. There was no business to be discussed. Heck, they took me out for drinks. It was to go to the College World Series. This, Your Honor, was August 21st, 2012. One fake check paid out of the trust account belonging to Pamela Pinckney for the amount of $6,490 to pay for a private plane so they could go party at the College World Series, and number two would be a check for $1,588.46. Back as far as 2012, the facts have shown Mr. Fleming has been stealing along with his buddy Alec Murdaugh. And so instantly we knew that things were different. That this claim from Mr. Fleming that he had been hoodooed by Alec Murdaugh like everybody else was not true. And then, as we go on deeper, we discover that he was a willing co-conspirator for nearly a decade with this man, and we'll start to go through those facts right now.
Unbelievable. Creighton next uses a traffic violation analogy that I find absolutely perfect for this case.
But also, I think that in the end, what we're going to see here is kind of like if this was traffic court and I'm a trooper. And Mr. Fleming, and the speed limit is 55, and Mr. Fleming's going to, I think, stand up and admit, hey, I was doing 58. And if I'm the trooper, I'm saying, no, Your Honor, we clocked him doing 90, and he was weaving in and out of traffic like it was a video game. That's going to be the rub here. And the real rub is going to be, what did Mr. Fleming know was going to happen with those millions of dollars that he delivered to Alec Murdaugh that were supposed to go to the Satterfields and never did? That's going to be the rub.
Next, he introduces a situation from 2012 where Corey and Alex pulled off a case involving Corey's family, where Alex put his name to it, but Corey actually did the work, just like with the Satterfield case, but in reverse. It was almost like a rehearsal for what they would later do with the Satterfield case.
He has a case where his family member is the defendant. And another family member is the plaintiff, essentially. And what they do in that case is really what happens in Satterfield. Essentially, Mr. Fleming, who's effectively the defendant, is doing the work and using Alec Murdaugh's name with his consent, who's supposedly the plaintiff's lawyer. And then they put in an order that is signed by a judge that the plaintiff's lawyer, Mr. Murdaugh, supposedly, is receiving $48,000 in legal fees. But it doesn't go to Mr. Murdaugh. It goes in his pocket. It's the same thing, just in reverse.
Mr. Waters then re-emphasizes his belief that Corey knew exactly what he was doing.
And so when he tries to claim to you later on that when Satterfield happened, when he was at his dirtiest, his motives were most pure. And he thought all that money was going to the boys, even though he never contacted them, never had any interaction with them. We know he knows how to do that because he did that with Miss Pinckney, but he never had any interaction with the Satterfield boys. And his own staff testified that everything Mr. Fleming did in the Satterfield matter was different. It was totally different. It was not the way it was supposed to be.
Oddly enough, there's money sitting in Miss Pinckney's account 6 years later, like a backup savings account for a rainy day.
There's still some money left in Mr. Fleming's trust account that belongs to Pamela Pinckney. And all of a sudden he sends an email to his staff saying, hey, we can disperse this money now. This is years later. This is 2017, when the first disbursement, as I just showed you, was from 2011.
Now remember the clip. She's lost her son, her daughter and niece were injured, and she was in the process of going through over a dozen surgeries. Her body is broken. Her heart is broken. Corey and Alex have stolen her money, not given her a single dime. They have left some in an account. Maybe they thought about giving it to her at some point to pass it off as the whole amount, but their greed keeps it tucked away just in case.
Your Honor knows this. There is no better for people doing this kind of work. There is nothing better, whether it's the attorney or the staff, than calling up the client and saying, guess what? I am the best lawyer in the world. I got $89,000 you didn't know you were getting. Come on down. Get your check. I think it says a lot that he doesn't call Miss Pinckney at all. He does not call her at all to say, guess what, Miss P? I got $89,000 for you. Bonus. Merry Christmas. Instead, it gets converted.
Some had gone to the College World Series. Some goes to Alex. And the rest just sits there.
And he says in his email to his staff, he says, we can disperse this money now. I need you to cut some checks. But first, we have some expenses that Murdaugh has. So please cut a check for roughly $4,500 and make that out to Murdaugh. And it's not legit at all. There's no expenses. That was Pamela Pinckney's money. And Mr. Fleming gave it to Mr. Murdaugh. But what he also did was have his staff cut a check from his trust account, not to Pamela Pinckney for the $89,000 that's remaining, but have it cut to PMPED. And it goes to PMPED, and Alec promptly converts it through the use of the fake Forge account.
He then moves on to explaining how Alex's fake Forge account worked.
A big part of this case is the fake Forge. And, Your Honor, I know that you understand these concepts, but I think you're going to hear from the defense that Mr. Fleming, despite this being his business, is going to claim that he doesn't.
Now in this next clip, he mentioned something called constructive receipt. So we're going to review that first. What is constructive receipt? It's about tax. Settlement monies are treated as actual receipt by the lawyer and constructive receipt by the client as soon as they are signed for. It's ownership. Some types of settlement payments are taxable, such as pain and suffering. These damages are considered emotional distress damages, not medical, so these are taxable. Once these kinds of damages are received, a tax is immediately considered due on them. This is what messes up a structured settlement. Now, where does this idea come from? Constructive receipt is considered a legal doctrine. It was based on a case in 1974, Davis v. Commissioner. The plaintiff, Beatrice Davis, received a very high-value check from her employer on December 31st. She wasn't at home when the post office attempted to deliver the check, so she wasn't able to actually collect it until the following year. So, because she didn't receive it in 1974, she didn't include it in her 1974 taxes. But the tax court ruled that she had constructively received the check in 1974 because that's when it was actually written and attempted to be delivered. This is so people don't hold on to money they're given and delay paying taxes on it. Now, this doctrine applies to all receivable money, including court settlements. As soon as that check is signed for, it's considered received and requires that any taxable portions be taxed. It therefore would change up all amounts if put in the hands of the receiver. Because of this, it changes the tax benefits of having a structured settlement. So imagine you're establishing a mortgage. They go through every detail. Every penny is accounted for. The loan company doesn't write you a check and you take that check and buy your house, because as soon as they would give you that money, you would have to pay tax on it. The totals would change. Instead, they make the agreement to pay the holder of the property. The interest is calculated. Every payment through the life of the loan is put in writing. The money doesn't touch your hands. It goes between the loaning bank and the title company. The title company then distributes it to the holder of the lien for any amount due left on that, and then the profit to the agent's fees, and finally the rest goes to the seller of the property. One little thing that comes up in the process can cause the entire mortgage to be rewritten. I know someone who had received a very small raise in the time between the acceptance of their offer and the closing. The entire agreement had to be rewritten at the last minute. When you're dealing with money, it's very detailed. So, with a settlement, once that money is received, which is simply signing for it, not even physically in the law firm's hand, let alone the client's hand, it is legally considered to have been received, just like Miss Beatrice Davis's check. It was not in her hands, but it had been signed off, issued out, mailed. Thus the term constructively received. There's also the term destructive receipt, which is basically when constructive receipt has occurred and ruined the structured settlement. Because a structured settlement is set up as carefully as a mortgage, one thing off can require a rewrite. Once money is received by the client, it is no longer in the hands of the payer to structure. Therefore, it is destroyed. The next point for a structured settlement is there has to be a payment schedule in place, just like with a mortgage. When you get your title work, there's a whole payment schedule set up. This payment schedule is a requirement to structure a settlement too, and we'll see the insurance company asking about this later because they understand how this works, and they know that this needs to be set up before they release funds if it's going to be a structured settlement, and that will come up again soon here.
What Forge does, the real Forge Consulting, it does not provide any annuity. It does not take money in the standard sense. It does not. It is only there as a consultant to match up a client with an annuity company that's going to provide the best rate of return at that particular time. It is a consultant. But what has to happen is the money has to go direct from the insurer for the defendant, or the defendant themselves if they're deep pocket, and it has to go straight to that annuity. It cannot at any time go to the lawyer or the conservator or the PR or the client themselves, because the second that happens, that's constructive receipt. And that blows the tax advantages out of the water. It's a basic concept for anyone who's doing plaintiff's work, which Mr. Fleming did for decades.
So bearing this in mind, Creighton introduces an email from the real Forge to Corey before this incident explaining how once a check is issued, constructive receipt has taken place and therefore it cannot be structured. This blows away the idea that Corey wasn't familiar with how Forge works and that a check could simply be cut directly to Forge. Because he's claiming he issued a check thinking it went to the real Forge, and that he was not aware that Alex had this fake Forge account and was fraudulently taking the money. I hope this whole concept of constructive receipt is clear now.
Your Honor, and this is a very significant email because it's an email from one of Mr. Fleming's staff members to the principal person at Forge. And Mr. Fleming, of course, is copied. In fact, the staff member says, and of course, like these emails, you have to read them from the back page going up. But what the staff member says is, Corey asked me to send you this letter. And if we see down at the bottom of the first page, the principal at Forge, of the real Forge, explains to them in great detail that because they already had the check cut to them, they didn't do it right. And the only solution they have if they want to set up a structure is to send the money back and get the check recut, because they've already had the constructive receipt. So if there was any doubt at all about whether or not Corey Fleming, as a plaintiff's lawyer, understood the reality of how this works, this email blows that out of the water. And there's others too that I'll get to in a minute. And why is that important? Because as I get to, when he hands those checks from his trust account, made out to just the word forge, and he doesn't mail them, he doesn't call the Satterfields, he doesn't call the PR, he either directly or constructively hands those checks directly to Albert.
He then moves on to show how this case was clearly in Corey's name only, that Alex was actually operating the whole thing, not Corey.
But if you talk to the family, if you talk to Tony Satterfield, they rarely have ever heard from Mr. Fleming. In fact, maybe the most significant thing that Mr. Fleming ever did was get Tony Satterfield to come down and sign over his responsibility as the PR so they could give it to Chad Westendorf from Palmetto State Bank so that the scheme could operate.
And if you'll remember, Tony Satterfield actually testified to this during the murder trial, that all of his communication went through Alex, not Corey. He then shows how Corey neglected his responsibilities to the Satterfields and intentionally made the checks out to Alex's fake forge.
He doesn't talk to the Satterfield boys. He's dispersing millions of dollars and doesn't call them up. He doesn't explain things to Chad Westendorf. And I think that tells you everything you need to know about his claim that he really, in his start, thought that they were getting that money when he handed it, made out to forge, which doesn't work, to his co-defendant, Al Murdaugh.
Next, he highlights how Corey was the operating force in setting up a situation for the fraud to actually take place from the beginning. Now, I've covered this in several videos, how Corey said to hold the check so they could switch out Tony as the personal representative for Gloria Estate, get Chad Westendorf in there instead so he could sign off on putting the money in forge. And here's Creighton explaining that as well.
This is an email from Corey to his staff member, November 13th, 2018. And attached to it was the letter from the defense attorney for the Lloyd's of London Insurance Company, pretty much saying, we're going to tender the policy limits. And what does Mr. Fleming say? He tells his staff member, we need to hold this until we can get the PR changed.
And this had to be done for this to be carried out. I mean, they couldn't have Tony come in, sign the money away, could they? Because then he would be aware that 1, the money was in, and 2, just how much it was. So they had to hold that check, get him in there to sign away his rights, and get Chad, who asked no questions and took his outrageous fees for the part he played in the theft. Now, if Corey really had no idea, he knows how to deal with clients and their settlements. Wouldn't he wonder why they were keeping Tony out of it? Why was Alex signing this over to Chad? I don't buy it. Creighton then goes on to call Chad Westendorf a patsy. Was he duped? Maybe. I mean, we can't read his mind, but I always come back to the fact that this man was and still is the vice president of this financial institution. He's educated. He should know this stuff, and if not, he should have looked into it. That's what I can't understand. When I'm watching a movie and I hear a term I've never heard, a place I've never heard of, a word I don't know, I will pause it and look it up on the spot because I want to know. I want to understand. And we're not even talking about something so important as millions of dollars of a court settlement where someone died. How did he not look into his responsibilities that he got paid so much for? How? Not only that, it was the fact that he was present for the shady conversation between Corey and Judge Mullen, where Corey was asking to break the law, to not file the settlement wins, to keep the information from getting to Mark Tinsley, because Alex was telling Mark he had no money, didn't want him to know that he'd just been sued for millions in insurance settlements. that the Satterfields had just gotten millions from him. So Chad is hearing this. He hears the judge agree to it. He leaves the room knowing that's what's going to happen. I would not feel comfortable witnessing that. I would have questions. I would start asking immediately. And if I wasn't comfortable to ask the people in the room in that moment, I would certainly ask a lawyer outside of those chambers. My other big question on that is, why wouldn't he want Tinsley to see that he'd just been sued for such a large amount? Wouldn't that help his case to Mark? He wants Mark to think he has no money. How easy is this? I lost my insurance, Mark. I just got sued for millions, Mark. I've got nothing left, Mark. Doesn't that make more sense that he'd want Mark to know that? I say the real reason they were hiding it is because they didn't want a record of it to get out, because they both knew they were going to steal it. And the more buried it was that they had gotten this settlement, the better chance to get away with it. Because how does Corey winning a case where he's going to get paid lawyers' fees, how does that put more money in Alex's pocket in the mind of any reputable lawyer? They're not going to look and go, oh, Corey won. Poor you. You lost. You've lost your insurance. You've lost this money. And think, oh, this is a better chance to sue you. That doesn't make sense. They wanted it hidden because they were going to steal it. And if I can see that, if I can come up with those questions in my mind, what was the judge thinking? She sits in a courtroom all day, every day. Why didn't it pop in her head? This doesn't make sense. Alex just had his insurance company sued, lost his insurance. This actually looks better for him. Why do they want to hide it? You know, it just the whole thing bugs me. It just bugs me. I don't think Chad's a patsy, and I don't know why Mullins wasn't brought to court on this. But anyway, now to my favorite clip of the whole hearing.
He holds on to that settlement. He doesn't call the Satterfields and say, great news. He brings Tony in and gets him to sign over his duties as PR to Chad Westenborn. And so when that money gets dispersed to Forge and handed to Alec Murdaugh, again, it's inconsistent with this idea that Mr. Fleming thought that money was really going where it's supposed to be. It doesn't make sense. Unless his defense is, I am the dumbest man alive.
Now, I didn't just laugh the first time I heard that. I cackled. But then I noticed Corey's face after he said that. Let me play that again with Corey's face right after.
It doesn't make sense. Unless his defense is, I am the dumbest man alive. We all know about Corey Fleming. He's been a lawyer for a long time. He's not the dumbest man alive. The appointment...
I just wonder, what's he thinking there? Is he thinking, well, maybe I am the dumbest man on earth? You know, who knows? I just thought that was pretty funny. Now, I mentioned before that this would come up again about having to set up the plan to structure a settlement. Now here, we find the Nautilus attorneys asking about it because they know it's all supposed to be done before the check gets cut. They are puzzled indeed, and Corey just shuts it down with, order the check.
Your Honor, I have a series of emails that go to Mr. Fleming from the defense attorney for Nautilus. And these are very crucial, Your Honor, as we think about what the facts show about what Mr. Fleming knew. We've already talked about the email that came from Michael Gunn. We've already talked about that Forge doesn't take money. We've talked about issues of constructive receipt. But what this shows is that the adjuster for Nautilus is emailing Mr. Grantland, who's the defense attorney for Nautilus, and saying, hey, we've got this settlement. I need to know some more details about how to cut this. Are they going to structure any of it? Do we need to have anything, a conservator appointed? And Mr. Grantland forwards that to Mr. Fleming. And Mr. Fleming says, John, order the check. The structure we have will include an administrator that serves the purpose of a conservator. And then follows up by sending him Chad Westendorf as the personal representative of the estate of Gloria Satterfield. Your Honor, that's State 13 that I hand up right now.
Now, his response still doesn't make sense to them. They know this isn't how it works, so they ask again in a more detailed question. They are no doubt wondering what is going on.
But obviously, the insurer and the defense attorney are confused because it doesn't make sense. So they follow up with another email. The adjuster says to the defense attorney, Mr. Graham, says, I need some clarification here. If he has a structure, don't we need to wait for information on the structure? Is he wanting us to fund the structure or is he funding it? If he wants us to fund it, it must go through Rainlord. If he doesn't want to fund the structure, does he want the funds to consist of a single check in the amount of $3.8 million payable to Chad Westendorf? And Mr. Grantland forwards that email on to Mr. Fleming saying, hey, what do you want to do, man? Mr. Fleming in Exhibit 14 says, I meant to add Moss, Clune, and Fleming, his law firm, to the check. I will need to check with Forge on Monday to double check.
Now, did you catch at the end where Corey pretends he's going to contact Forge to ask, but he claims he was duped by Alex? Did he ever reach out to the real Forge to ask? No, and that's very telling. Then the bazinga moment.
The evidence shows, of course, is that Mr. Fleming is having no conversations with real Forge during this time. He's not reached out to them. They don't have a case. He's had a few interactions with Mr. Fleming, seen him at the trial lawyers conference, which of course is where all these kind of issues are discussed. They're a huge presence there because of the services they provide to plaintiffs' attorneys. Well, that doesn't answer the question. And so, again, Mr. Grantland on March 30th, 2019 is sending the letter from the adjuster saying, please, let me know what I need to tell her. And this is Mr. Fleming's response, Your Honor. This is States 15, and this is very telling. He says, standard check. Chad Westendorf's PR and Moss, Coon, Fleming's attorneys. Standard check. The question is, structure or standard check? And Mr. Fleming's answer is standard check. If there's any illusion whatsoever about whether or not he thought there was a real structure, first of all, the way he's cutting the check doesn't work. And he answers the question right there to Mr. Grant. Standard check.
Now we get back to that rainy day money they've kept tucked away. And here comes the rain.
While that's going on, just a few days later, 3 days later on April 4th, 2019, still out of the $505,000 settlement, Mr. Fleming goes to his staff member and says, I need you to cut another check out of the Satterfield money. I need you to make a check for $8,500 and make it out to me for expenses for the estate of Doris Satterfield. No documentation, and again, those were fraudulent. Your Honor, going back to that first check he had cut in January for $8,000, when we look at his account, Your Honor, when he went down to a staff member and said, I need you to cut me this check, his account was getting really low. And the second that money comes in, he pays his mortgage and a large credit card debt.
You say he, you're referring to?
To Mr. Fleming.
Mr. Fleming.
Yes. When he steals that first $8,000, you look at his account, it's pretty low. And the second he gets that money in, he's making those two large payments that needed to be made. If that tells you anything about the motives, it's right there.
But he wasn't done yet. Rainy days came again.
The second check, the one I just referred to, from April 4th, 2019, for $8,500, he puts that in his account. And what we see is that immediately he has to pay pretty much all of it to the IRS. And his account, again, was low. He needed that money to make that payment.
So while Miss Pinckney endured pain, surgeries, and heartbreak, these guys lived beyond their means and stole her money to do it. Now comes the big over $3 million check. The disbursement sheets have to come out of Corey's law firm since he's the named attorney. So while his assistant is trying to make sense of it, he, not Alex, arranges the math.
And so what happens after that is Mr. Fleming's, they have $3.8 million now. What do they do with it? Well, Mr. Fleming, his staff member, dutifully starts to try to put together a disbursement sheet, as she normally would, where she's trying to identify expenses and liens and hold that money and figure it all out, and she prepares her best initial attempt. But Mr. Fleming stops her. Says, no. States 19, put these numbers down. You put these numbers down. And what he has on there is that he is getting $168,333.33 in attorney's fees from the Lloyd settlement, and he is getting $1,266,666.67 from the Nautilus settlement, which would be the standard percentage cut. That's very significant too when Mr. Fleming tries to claim, as he does, that he didn't know that Alec was going to take his half of the fees. Because what the math works out to be, is what's very common in the plaintiff's world, which is exactly what Your Honor heard testimony about at the trial of Alec. The fee split with Chris Wilson. And when you look at the math works out to be a fee split between Corey Fleming and Alec Murdaugh. And that's how the case was conducted. And again, if we go back, we look at what they did with the case back in 2012 to 2014 when Corey was the beneficiary of getting legal fees that were supposed to go to the plaintiff's attorney. We look at what we know about what Corey knows about how Forge works. We know that the check doesn't cut. We saw the email where he says, cut standard check. And then we look at the disbursement sheet that he actually gets Chad Westendorf to sign, and it's got the full amount of attorney fees in there. It also has $105,000 even to the nose of prosecution expenses, which are fraudulent. Doesn't exist. Theft.
And now, my second favorite statement of this hearing.
These two men looked at the cases they had as if it were a pantry, and they could just open the door and goodies would just drop out.
Closing things up, he outlines the total financial crimes one more time.
Summarized, we've been through a lot, but I just want to go through those numbers very quickly and the indictments they represent, and then I will sit down. But for 2021 GS 4730, we have the 3 Forge Satterfield checks. $403,500 is the first one, January 2019. The $2.9 million check, which was May of 2019. The $118,000 check, which is October of 2020 when they did that very suspect stipulation of dismissal. And then the $113,800 that was remaining. And the total there of money is $3,597,231.95, just for that aspect of the crimes that Mr. Fleming has committed. 2021 GS 4730, we have the 3 fraudulent expense checks that Mr. Fleming wrote himself or had written to him out of the Satterfield money. The first one is $8,000 on January 17th, 2019. The second is $8,500 in April of 2019. The third is $9,700 in January of 2020. And that totals $26,200. The Satterfield total, combining those two amounts, is $3,623,431.95. Moving on to the Pinckney matter, 2022 GS 4702. You have the 2 checks to Crosswind that Mr. Fleming had cut, billed as a medical expense, but instead were for his party on the profit claim. The first one is $6,490. The second one is $1,588.46 for a total of $8,078.46. Then you also have the check of the remaining trust amounts that belonged to Ms. P. That instead of calling her up and saying, great news, he had converted for Mr. Murdaugh and sent to PMPED. And that's $89,133.44. Then you have the expense check that he had cut to Mr. Murdaugh for $45.60. And so in that amount, we have $101,771.90 for a grand total attributable to Mr. Fleming's abuse of his law license in state court of $3,725,203.85. Your Honor, those are the facts as it relates to me. Thank you.
Did you see this guy's face? He rolled his eyes. There's no jury here to convince or perform in front of. This is what he's literally sitting there feeling in this moment. Miss Pinkney is a few yards away from him with all her pain and loss, and this is what this guy is feeling in this moment, hearing these words? Sorry the truth annoys you, Mr. Defender, but justice needs to be served here.
Of his law license in state court of $3,725,203.85.
And now we get to the moment where we hear from Corey, who doesn't sound well.
Mr. Fleming, do you disagree with any of the statements made by Mr. Waters?
Your Honor, I agree that there are facts that Mr. Waters stated that establish my guilt on each of the indictments. However, there are certain facts that are not material to my guilt that I think I would like to be able to address in sentencing.
Question is, do you disagree with any of the statements by Mr. Fleming and your responses? Do you disagree with any statements made by Mr. Waters and your responses?
I do disagree with some of the statements that were made by Mr. Waters, yes, sir. I, however, agree that that there were sufficient facts provided in court that I agree with that establish my guilt on each of the indictments.
As I saw him walk out, a broken, defeated man, saw his family sitting in court having to hear all these details that maybe before this they hadn't really heard. Maybe he'd minimized it to them or just never talked to them about it, but they had to sit there and hear every word of this. I feel for his family, I do. What a waste of a talented mind, of years of university and law school, and this is what it came to, because of greed. Now, immediately following his hearing, there's a quick hearing for Russell Laffitte.
Next case is State versus Russell Laffitte. He has been indicted in 3 state grand jury indictments,
where Judge Newman first signs an order to access some of Russell's funds to pay attorney's fees. Next, his defense is trying to put off the state trial as long as possible. Creighton has a big trial in November and December, so he's hoping for October, but Russell's attorneys say they won't be ready. Mr. Rutherford has legislative duties after the new year that will keep him unable to hold a trial, so if this does not get started in October, it looks like his trial will be put off till fall of next year.
As Your Honor knows, the last time we appeared before you, I had not been in the case for long. Mr. Rutherford had just joined. Since our appearance before Your Honor, Judge Gergel has scheduled and has now held a sentencing hearing in the federal case. And Mr. Laffitte was sentenced to 84 months in federal prison. He is appealing. Currently, he's appealing that conviction and sentence. We have asked the Fourth Circuit to grant him an appeal bond. I do not have a decision on the appeal bond as of yet, Your Honor. I will tell Your Honor that I spent no time preparing for a state trial because I spent all my time on this case preparing to deal with his federal issues, to deal with his motion for a new trial, to deal with the sentencing, and now deal with the appeal. And Mr. Waters and I have talked about that. And perhaps I think we're going to jointly propose another status conference with Your Honor after the Fourth Circuit decides this appeal. That's what I hope we're going to do.
They then set up a time tentatively for Thursday, September 14th, with hearings on that same day for Corey, Russell, and Alex. And just picturing that, I wonder what it's going to feel like for them to sit together in the same room after all of this has blown up in their faces. As they sit there, reliving these moments where they did this thievery, where maybe they sat and laughed or celebrated when they walked out with millions of dollars. What does it feel like now? Do they sit there hating each other and blaming each other? That tension of that upcoming day when they're all going to be sitting there, feeling these feelings, I bet you can cut it with a knife. Can't wait to hear the results of that day's court. In other news, a document was filed on Friday from plaintiffs in Russell's federal trial. It's their response to the motion for release to pending appeal that we discussed in the last updates with Cassidy Video. I'll get to that soon, as well as to keep you updated with all these filings, hearings, and such a twisty case. Till then, this is Cassidy O'Connell saying stay well and stay tuned.